Yes. Next. Hello there. The actual matter, Malo, today, Malo, tomorrow it will be discussed, Malo. Very tomorrow. And Malo, one I think filed Malo the last week for packaging of the interim order. It may come up with 5 kilos. Malo, another matter, Malo, item number 5. But this matter is hard by for number 10, Malo.
Ah, I know.
So it will be listed before that, Malo, on second, Malo, by the
Who's for the other side?
I'm for that.
Okay, Mr. Jain Sahewala, then a senior counsel for the petitioner, and Mr.
N. Barwa.
N. Barwa for the respondents. Submit that the matter is partnered by the Honorable Mr. Justice Subito Saikya. Accordingly, with this matter before the Honorable Mr. Justice Subito.
1 second, Malo.
1 second.
Hello, in regard to item number 6,
Yes.
look, can you lordship accommodate me for the day of?
I appear for the petition.
You haven't filed any affidavit?
Affidavit has been filed.
Yes,
File.
it's ready in all respect.
Right. Mr. S. Datta, then senior counsel for the respondent number 6. Prays for adjournment of the matter. The same not being objected by the petitioner's counsel. This is the matter after?
Can you come up next week, my lord, in a fixed date? 8th of May.
Look, after 8 months, any day after 8.
13 PPT. I am not going to be 15.
Possibly 13, we want to say it's unlucky for you.
But that may also
Okay, 15.
15.
15.
15.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 11 of today's news. So in this matter, S. Sharma Senior is appearing for the petitioners. He has some difficulty today.
Who's for the other side? Any objection?
The matter is concerned, it relates to supply of the IP article to the Assam Medical College. Can it be on 8? Report the personal difficulty.
On the prayer for adjournment made by Mr. S. Sharma, then counsel for the petition. And which is not objected to by Mr. P. Gopal, then counsel for the respondents. This is the matter on this.
Sure, I'd like to mention item number 3 and 4. The matter may be adjourned for the day.
I'm for a petition.
Huh?
I'm for a petition.
Why adjourn?
Mr. Esbora is not available today due to some personal difficulty.
What remains in this? What remains, Mr. Counsel? What is the case about?
When you contact from
I know.
they have student work order, my lord, at the rupees, my lord, 11,400. Now, when I submitted that bill, my lord, they, my lord, people, my lord, only 6,000. Work order, my lord, they admitted, my lord,
But what is the rate? What is the rate for the dumpers?
11,400.
But they're giving you less.
Yes, 600. They say that in the market, my lord, 600.
But as per the at time of acceptance of your tender,
Yes, sir.
your tender was accepted at the rate of 11,000.
Yes, sir. Now, when I submit the bill, my lord, they
Yeah,
giving only 6,000.
right. Yes, when?
On 15,
15 already, one case. 15.
and 16.
Correct. On the prayer for adjournment made by Miss
J. Rajkumari.
J.
Rajkumari.
Rajkumari for the respondent GMC
J. On behalf of Mr. Esbora.
on behalf of Mr.
Esbora.
S. Bora, which is not objected to by Mr. D. Gobel. Then counsel for the petitioner. List the matter on 16. The petitioner's case is that his dumpers were hired at the rate of rupees 1100. How much?
11,400.
11,400. Yet, in terms of the tender submitted by him. However, his bills were paid by the GMC at the rate of rupees
6,000.
6,000 per dumper. This is the matter. Huh? So that is the small, that's the small issue, nothing.
Also there.
May I please, your lordship?
Huh?
Only time Srinagar is there.
Yeah, what remains? That's what remains. Well, I said the petitioners also submit that the present case is covered by the, that's when an order passed in,
I have to say, man.
huh?
By the coordinate bench.
Is covered by a coordinate bench. In WPC number,
I'll give my.
you give it to her. WPC number.
May I please, your lordship? Lordship, with regard to item number 11, which I have already mentioned, lordship, there's an interim order in that, this lordship.
Okay, in item 11, interim order to continue to the.
May I please also, my lord, I'd like to mention item number 20, supplementary list, my lord.
Yes,
The council of the other side, my lord, they have filed affidavit in opposition yesterday, my lord. So, my lord, has filed reply, some reply, 2 weeks time maybe be taken. Well, another friend is here, my lord.
okay, Mr.
Please check, my lord.
T. Sheikh appearing for the petition is granted 3 weeks time to file affidavit in reply to the affidavit submitted by
This one number 5, my lord.
point number 5.
Additional.
To the additional affidavit.
Yes.
Okay, when it's not in the file, the additional affidavit.
Yes, sir.
Okay,
Not in
additional
that.
affidavit filed by the respondent, huh? Then you write, registry to place the additional affidavit in the record.
Thank you.
Complete, my lord. My lord, I'd like to mention item number 7 of daily list.
Yes,
The learned counsel for a petitioner has gone out of station, my lord. This matter may kindly be taken up next time.
who is for the APDCL?
Lordship, I'm looking for it.
Yeah, are you filing affidavit?
We'll file affidavit, Lordship.
Huh?
We'll file affidavit.
When? When will you file?
Lordship, let it come after 2 weeks, Lordship. After 2 weeks.
Yes, ma'am.
After 2 weeks means after 10 years also. What is the upper limit?
Lordship, in this matter, even I don't have the brief, even I'm not having the brief.
Then who's having the brief?
Most probably Mr. K.P. Pathak or Mr. Beach.
Mr. KV Pathak is behind you. Are you filing any affidavit?
We will file a short.
Where?
3 weeks time instructions are still awaiting.
Say that. You.
I did not, I did not,
It should be you who should be asking for adjournments. not
I
that.
was not aware of this.
Look at the causes at times.
No, I'm
We were
aware
not
of
made
this.
aware.
I would have made that prayer. There are some, because this matter, one round, this is the second round of litigation. So after the appellate authority has decided, very little needs to be disputed on facts here. Perhaps a short affidavit, now that we have time.
Okay, Mr. KP Pathak, learned counsel for the APDCL is granted
3 weeks time.
3 weeks time to file affidavit in the position. This is the matter of the thing.
Your Lordship, if you consider the other side, I beg to mention item number 17 and 18, Your Lordship.
17, 18,
Yes,
yes.
sir. In this matter, additionally, Mr. P. N. Goswami, he's appearing.
Huh?
Mr. P. N. Goswami, he's appearing, Your Lordship. He has to go out of station for treatment, Your Lordship. So matter be taken up on
N. Goswami is appearing for whom? For the
For the
APDCL?
APDCL.
Okay, right.
I'm for a petition.
Okay. Any objection? No,
Because of
we are not very happy because 2017 matters.
Actually, because of medical reasons, he have informed me today morning.
Right. Adjournment prayer has been made on behalf of Mr. P. N. Goswami, learned counsel for the APDCL. On the ground that has gone for medical examination. Outside the state.
Outside.
The same not being objected by the petitioner's counsel. This is the matter after
On 6th, Your Lordship.
6th or 8th.
on 6th. 6th.
Published.
Did your lordships, my lords, with the consent of the other side, my lords, I beg to mention item number 9, my lords.
9.
Yes, my lords, we are also required to file a reply, my lords, affidavit in reply
Yes.
for the petitioner.
Okay, right. Mr.
T das, my lords.
T. Das.
Yes.
Learned counsel appearing for the petitioners is granted.
My lords, 2 weeks time, maybe.
2 weeks time
On
to file.
16th,
Huh?
Lordship. On 16th of
2
May.
weeks time to file affidavit in a position.
A reply, my lords.
Affidavit reply. This is the matter on 16th.
My lords, there is an interim order, my lords, that may.
Interim order to continue till the next day.
Okay.
There are your tender conditions, there are some I mean, they're not matching.
But ultimately, it's an online bidding. And in the online bidding, the EMD amount is stated, which the other bidders have also quoted the same amount and deposited. So there is no dispute as such. tender papers, there was some discrepancy. Ultimately, they have to deposit in the online portal. There, the figure is quoted there. And the other bidders have,
So they did not submit that.
yes, paragraph 7 of your case will already is very clear. They say they wanted to submit, they could not submit. That's the only.
We'll
ground.
file affidavit.
It's a very small campus.
In reply, we will contain to the.
Anyways, they want to file a reply, let them file a reply. 16th of May.
With your best.
Okay.
May it please your lordship. What should be the consent from the other side? I am paying for an adjournment in respect of item number 19, lordship.
19.
Lordship, last,
Why?
well, the conducting council is out of station, lordship.
What you are appearing for the petition.
Who is the conducting council?
B Pathak, lordship.
Mr. B. Pathak. Correct. Adjournment prayer has been made on behalf of Mr. B. Pathak, learned counsel for the respondent number 1, which is not objected to by the petitioner's counsel.
That's a judgment, interim order.
List the matter when,
Lordship, over 2 weeks.
list the matter of 2 weeks, interim order to continue till then.
May I please, my lord, with the consent of the other side, I'd like to mention item number 8 of the daily list, my lord.
It is,
Our affidavit in opposition is ready and today
huh?
our affidavit in opposition is ready, my lord, and today we are going to send it for vetting, my lord. My lord, may I please to post this matter in the next week, my lord.
Who is for the petitioner?
I am for it.
What is your case? Okay, what do you want?
What's it, case is termination, or it's termination?
Correct, correct, terminated twice. Is there any arbitration clause?
No, Lord.
No. You want to continue with the contract? Yeah, it has been terminated. What is the reason for termination?
Lordship, I have not,
Finish on time.
continued contract with you.
Huh?
Lordship, I am not, continuing the work. So I have, said, Lordship, raised that, some problems are there. They have not, authorized not fulfilled that, condition. That's all.
Right. Mr.
H. Purva, my lord,
H. Barua appearing for the PWD,
on behalf of B. Google, my lord.
appearing on behalf of Mr. B. Gogoi, standing counsel BWD. Praise for
1 week time, my lord.
a week's time to file affidavit. As the same is under preparation.
My lord, it has gone for vetting today.
As the same has gone for vetting. The same not being objected by the petitioner's counsel, this is the matter after a week,
Next week, my lord.
after a week. Then you write, the matter pertains to termination of the petitioner's contract work. Full stop. The petitioner's contract work had initially been terminated on 9/11/2020. Due to which the petitioner filed WPC 7436 of 2020. Full stop. During the pendency of WPC 7436 of 2022. The termination order of the petitioner's contract work was withdrawn by the respondent. However, the petitioner's contract work has again been terminated on 17th of 2024. Due to which the petitioner had filed WPC 100 of 2025. Correct?
But,
Now what has happened to that case?
Lordship, in that case, we have, we could not submit two documents. So accordingly, that was withdrawn and filed this, two
Full stop. The WPC 100 of 2025 was withdrawn as the said writ petition had been filed without certain documents. Full stop. Thus, the present writ petition challenging the termination of the petitioner's contract. This is the matter after a week.
There is an interim order that may.
Interim order to continue till the next week.
Yes, my lord.
Wait, please. Item number 13, seeking a losses indulgence. I have to file and reply to the affidavit filed by the government, health department. 1 week's time may be granted us. On 8th of May,
Mr. A. Sharma appearing for the petitioner is granted a week's time to file affidavit in reply to the affidavit filed by the respondent number. Filed by who?
Health department.
Filed by the health department. So the matter pertains to the rejection of the petitioner's technical book by the respondent.
Other aspect is private respondent steps has not been completed as of yet. They were supposed to give dusty. That is, I think, not completed.
They are supposed to give dusty, you're the petitioner.
No, we have taken registered steps as well as they had taken the responsibility to serve upon the private respondent on their own through dusty. That order is there. So
Let me see. 80% of the colleges have finished. Good. Some more, I need some more, then we can all relax.
it doesn't happen all days, Lordship.
Huh?
It doesn't happen all days. Sometimes the Lordship is sitting till late.
Small mercies.
The first order.
Yes, what has happened?
Lordship, I'll take the inspection, Lordship. Let it come on 8.
Have you given the extra copy?
That has been done. From our side, what was supposed to be
Okay,
done,
right.
we've done it.
In the next para. In terms of the order dated 2060-2025, the petitioner was to give an extra copy of the writ petition to Mr. B. Gogoi, Learned Standing Council, Health Department, for serving notice on the respondent number 7 to the officials of the Health Department. Mr. D. Upamani, Learned Council for the Health Department shall obtain instructions as to whether notice has been served upon the respondent number 7. In view of the fact that Mr. A. Sharma, Learned Counsel for the petitioner, submits that extra copy of the writ petition has been provided to, extra copy of the writ petition for the respondent number 7 has been provided to whom?
With the health department, I think B. Gogoi,
To Mr. B. Gogoi. Earlier. This is the matter after?
On 8, Lordship.
On 8th of May. Obliged.
Highly obliged.
Lordship, in this case, Lordship has directed me to file affidavit.
Huh?
Lordship has directed me to file the affidavit. Actually, earlier it was fixed on 7. Yesterday, I tried to file the affidavit. I could not find the counsel for the petitioner for the counsel. Lordship, counsel for-
Yesterday, it was late in the evening and actually our work was over, so
Today-
today it was served. Today morning, the copy was served to us.
and
Okay, you have not filed it.
today I have filed.
Okay. So what do you want?
So Lordship, at least 2 weeks for going through. If reply is necessary, we'll file reply.
I think we'll release it from partner. I think.
Nothing, yes.
Huh?
No, nothing is, Lordship is already on that day I have made the argument. That is Lordship. Lordship directed me to annex that.
You
to-
file, why 2 weeks?
Yes. Because it's very simple
Actually, it's,
affidavit, Lordship. Only speak.
Let us-
Sorry, 2 affidavits have been filed, one by the school, one by CPS.
Okay.
Okay.
So basically, they have said civil court. Their case is basically.
Okay.
What is any problem going
No,
with the civil court?
No, Lordship, now if we see the school's affidavit and this, if we read in totality, school says that because the school's affidavit was filed 2 days earlier.
So it's the school says that because of typographical mistake, they had sent a wrong date of birth. So now, my lord, if a typographical mistake's date of birth is considered as gospel truth, and all other documents that I'm showing, that is nothing. So
No,
on that-
but then this court has also seen your birth certificate.
Yes.
yes, I have taken a telephonic instruction on that also, that how did it happen? Because of course, apparently the handwritings were different. So what the parents, because my petitioner does not have personal knowledge. He was a child at that time, just 3 months old. So his parents say that the details was written by the nurse. Signature and the above portion was written by the superintendent of the hospital, who as per government notification is the registrar of birth and death.
Anyway, you file your affidavit within a week. Then since you have already taken instructions, nothing.
No, on that, but on this, of course, this affidavit is, we have received. today.
Within a week. Within 2 weeks, you want, okay, right. Ms. R. Bora, Learned Standing Council CBC submits that. Affidavit in opposition will be filed today, while a copy of the same has already been furnished to Mr. M.K.
the
Chowdhury,
second.
Learned Counsel for the petition. So, Mr. M.K. Chowdhury is granted 2 weeks time to file affidavit in reply to the affidavit filed by the CBS. This is the matter. Here for
For school, for Kendriya Vidyalaya.
Mr. M.K. Majumdar appears for the respondent number 4. This is the matter on, give a date. Okay, two.
Until May.
19.
Of like.
15. If possible, can it be a Tuesday?
No, 15 is Thursday. Thursday.
If just a little accommodation, then a Tuesday. Ma'am, Tuesday, Thursday. Okay, ma'am has no issue. 13. Obliged.
In item number 2, Lordship may kindly.
13, the 2 weeks will not come, no? It will be complete, it is beginning.
Lordship, can this matter be taken up?
Yes. Huh?
Can this matter be taken up for some time?
I'll start, let him come. I'll take some.
Who is the council?
Yeah, R. Gogoi, Lordship. He is on legs on item number.
They have filed affidavit
Code number
already. They have already filed the affidavit.
Let us see, they might want to hear what you have to say.
My lordship,
They might want to hear what you have to say.
After 10-15 minutes.
I don't get it.
They might want to hear what you are going to say.
They might want to hear.
Yes, he's senior.
Yeah.
So if he's not here, he cannot hear what you are saying, what points you are going to take up.
Correct.
So that's what.
Correct.
So let's wait.
After some time.
In this case, I filed the application for vacating. Who are you? I am the private respondent number 6, my lord, who got the settlement.
Yes,
And the
what the time
petitioner
period?
is the tenderer who failed to submit the earnest money. And now. Failed to submit? Earnest money. Earnest money? Yes. Earnest money or what? Earnest money in this case? Tender, it's a tender for. So how can, so in this tender, it cannot submit earnest money. Earnest money is a requirement for filing your, I said earnest money, but government, according to the government, it is security, fishery security. Along with the tender, they have to. Along with the tender, it has to be submitted. They fail. In spite of
Just for the
that.
time being, Lordship, I think it's,
Where is the senior?
she's coming, Lordship.
She. Who is she?
Papia Chakravarti, Lordship.
Huh?
P Chakravarti.
Anyway, so what is the case about? No, all the cases are being adjourned. In this case, Miller, the petitioner filed a petition challenging that I am a defaulter. Yes. Once they approach this honorable court, then this honorable dispose of the petition with a direction to the government or authority to hear the matters and pass a final order. Accordingly, after hearing both sides, the authority held that I am not a defaulter. Then the settlement order was issued.
Thereafter, after 1 month, they approached this honorable court with a prayer to set aside that impugned order. What I submitted before your lordship, as per terms and conditions of the tender notice.
Now let us see this NIT. Which NIT is this?
Yes, that will be better. At
We will
page-
dispose
your
of the entire matter, nothing, no halfway business.
Page 14, my lord,
Page
or 21.
Page 21, yes,
Has your lordship got?
Yes.
In fact, NIT at page 19.
page
there,
19,
This is the NIT.
yes. NIT dated,
NIT dated 1/10/2024.
110 for 7 years, okay, then
Then your lordship kindly turn to page 21.
page 20, yes,
This is the tender form, printed form supplied by the authority.
okay,
Now your lordship turn to page 22.
page 20,
Page 22, relevant line.
yes,
The tenderer should enclose the following document.
yes,
Am I right?
yes,
Then your lordship, NGA now. Has your lordship got it?
Yes.
Proof regarding 15% deposit of first year reserve price along with the date.
a
and
blank name, a bank name.
bank name. And when I said in my application, they said that there is no such clause, but clause is there.
If I may submit, my lord.
Just a minute, just a minute. So this proof regarding 15%, so you deposited this?
I am deposited.
If-
I am not also defaulter as per the government.
Just a minute. So you have deposited this?
Yes,
Now what is their case?
their case, that I am a defaulter.
So nothing to do with this, 15% deposit.
Because he is a tender.
The defaulter will be with regard to some earlier case,
Yes, nothing to.
not with
Not
regard
to
to
this,
this.
yes.
So their basic case is that you are a defaulter
Huh.
with regard to some other settlement, correct? Of the same fishery or different fishery?
Different figure.
Which fishery is that?
Balaihuti Group Fishery.
Page?
My lord, the information furnished by in the RTI
Page-
is page 32. Yeah, 32 is the vernacular. Translated copy is page 30.
30. Okay, where is the provision which says that defaulter cannot participate or cannot be
That
selected?
is a mandatory provision as per the
Show me, show me, show me.
fishery rules.
The same fishery rules.
No, my lord, there is no such, not in the fishery rule.
I do,
And in NIT also.
it's
NIT
in the NIT, show me.
Record है क्या ना? Record चाहिए क्या?
Page 22, my lord.
22.
It is translated copy. Bakijai clearance certificate. This is the mandatory requirement.
Baki Jai clearance certificate.
Certificate. So, why it is.
So is there any Baki Jai case against him?
My lord, we had made an RTI application that whether there is any Bakijai pending, outstanding dues. And my lord, this is furnished to me as page 30 by
No,
the.
you see, madam, the
Right.
thing is that for the while submitting his application or his tender, did he submit any Baki Jai clearance certificate?
My lord.
He must have.
So,
So now the thing is that he has got a Baki Jai clearance according to him. According to you, he is a defaulter. Now that is a question of fact. Let the authorities decide whether.
Your lordship was directed it.
Where?
Your lordship page, turn to page,
it is in earlier round of litigation. at
your
page
lordship page at
33.
33.
33.
Your lordship,
Page 35 is relevant.
This is with regard to
this fishery, my lord, this tender process.
This time.
the present Kalkachia.
Yes.
Okay, so
So,
Just a minute, this is,
paragraph 6 is irrelevant.
this is 7/10/24,
Yes, my lord.
Earlier on the litigation.
but this NIT is 1/10/24 you were saying. Yeah, 1/10/24.
1/10/24, my lord, they approach after that.
No, so out here, this order is wrong, it appears. Tender notice is 7/10/24.
7/10/24. And this court order is 17/12/24.
You're not getting it. You come to page 19.
Yes, my lord.
19 says 1/10/24.
1/10/24.
So tender notice is 1/10/24.
20/24.
But at page 34, it talks of tender notice dated 7/10/24. So there is a difference. So either this is a mistake,
Our mistake, my lord, not so,
your mistake,
not my mistake.
their mistake,
Their mistake.
their
Then
mistake.
lordship directed.
Ah,
Allegation are same, my lord.
okay.
It is regarding the same fishery,
Same fishery.
Same.
So same tender notice.
same time.
So why twice?
No, my lord, there was a direction from this court that they will examine the matter.
Ah,
How did,
there was action to the respondent to consider whether so.
now page, annexure 7, page 36, my lord.
Page 36, yes,
The order
yes,
pursuant to this direction.
yes.
Today on 30/12/24, hearing pursuant to direction of the Honorable Guwahati High Court application dated so-and-so had taken place in my office in presence of Shri Mahendra Das, son of so-and-so. In today's hearing, the applicant as well as of opposite sides opinion have been considered. In this connection, it is informed to all that information furnished under RTI by this office under letter so-and-so regarding outstanding revenue from 2009 to 16 in connection with Balaisuti Group Fishery run by the lessee Kalu Das. However, he got possession of the said fishery only in the year 21. This office letter dated so-and-so 38/24 issued to Anandaram Das under RBI had furnished details of outstanding revenue from 2012 to 26. Since
This line, my lord, some correction is required, my lord. According to the English, particular, in which since 2009 to 2016, lessee was different.
I'll just
my
read
lord,
the vernacular.
particular, yes, read it. যিহেতু 2009 চনৰ পৰা 16 চন ইংৰাজী চনলৈ লেচি বেলেগ আছিল
Fishery to lessee Kalu Das আছিল।
সেই তেৰিকাত যিহেতু পুলিচ ষ্টপৰ পিছত যিহেতু 2009 ৰ পৰা 2016 চনলৈ লেচি বেলেগ আছিল সেইটোকে গোপাল চৰকাৰ তথা গোপাল আদা দিয়া ৰাজহৰ পৰিমাণ টকা বৰ্তমানলৈ This is different man as per the order itself. কালু গভর্নমেন্টের বুকে থাকে যেহেতু থাকে লেসি বেলেগ আছে হ্যাঁ ফল সরকারের বেলেগ on 2019 2016 lessee was
My lord, in my rejoinder, I have stated that this is manipulated and this Kalu Das has been introduced to have been running the fishery from 2009 to.
Which fishery, which fishery? Which fishery are you talking about?
My lord, he was defaulter with regard to Balaisuti Group fishery. Therefore, my lord, records regarding that period was called for from the government advocate. If Kalu Das was.
Just a minute. So, according to you, he is a defaulter with regard to Balaisuti Group fishery. Okay. Now, what is going to be settled is Kolgachia, no, is Chatla, 79 number. So now we have to see whether he was a defaulter from 2012 to 2026. How can it be 26 when now it's already 25 only, 26 will come only next
It
year.
was the period, 7 years period. Yes.
2012 to 2026 is 14 years period.
We got.
Come to page 30. 2012, page 30 at the bottom, is due for him from 2012 to 2026. How can it be? And what is the respondent number 6? The name of the respondent number 6?
Gopal Sarkar.
Gopal Chandradas.
Sarkar.
Huh?
Gopal Sarkar.
But look at the course title.
Yes, Milord. My name was wrongly.
Your name is Gopal Sarkar.
Title was wrongly.
Your name is Gopal Sarkar.
My lord. My lord, according to note sheet, my lord, a note sheet was put up on 2016. What she alleged that I am a defaulter, as per notice of sale of fishery, NIT, tender box is open on 2012 in front of the tenderer at the office number
2012, which year? Which year?
2016, which
12.
they allege that I am a defaulter.
Ha.
That note sheet, my lord, tender
Ah.
was open
Ha.
and that record. Total 6 number of tenderer are found. Gopal Das, serial number, Gopal Das is different person. And they presume that Gopal Das and Gopal Sarkar is same. My name is Gopal Sarkar.
Ah, okay.
Gopal Das was one of that, and he was his tender have not submitted.
And you have been settled with the fishery now? Already
Now,
settled?
now.
Where is the settlement order?
That is, I have annexed with my application itself, my lord. And Gopal Das, that time, Ernest Party was not submitted and rejected his tender. How they can say this is the, not cheap. At page 12, my lord, in my application for
Page 11.
12,
Okay.
12, my lord. On 1/1/25, they issued the settlement order. As your office got it.
Please read.
Page 12, my lord.
Yeah.
In my application, this is the order. Page 13, the memo number and other.
Gopal Sarkar.
Yes.
Gopal Das and Gopal Sarkar, I have stated on oath, my lord, in paragraph 8 of my affidavit.
In paragraph 8.
Yes, my lord. And Gopal Das alias Sarkar was the lessee of Balashoti Group Fishery from 2012 to 26.
Out, para 8.
Para 8 of my affidavit rejoinder. In the I. In the I, my lord, the objection filed by me. Page 42.
Page 42?
Page 42. It is the affidavit in objection in the I. Yeah, paragraph 8, man. I stated that Gopal Das alias Sarkar, the same person. Ma'am. This is how.
No. Well, the RTI information furnished by the clearly mentioned that Gopal Das alias
Gopal Das
Sarkar.
alias.
Let us see.
Yeah, same person.
Where does it say alias Sarkar?
My lord, I have stated in paragraph 8.
You have stated in paragraph 8, but you are referring to a document furnished under the RTI Act. Show me the document furnished under the RTI Act.
Page 32. Page 32 is vernacular.
No, your translation is there at page 30. Then where does it say alias Sarkar? Where does it say that? Don't make up your translation, which is not as per the vernacular.
My lord, in the lease, which was in the tender 2016, Gopal Das or Kalu Das, son of late Gayanath Das, was settled.
Was?
Son of Gayanath Das.
Was?
Settled with the Balashoti fishery.
Okay. Not this
Das.
Gopal.
Not this Gopal Sarkar. Assume,
And this talks about Gopal Chandra Das, doesn't talk about any Sarkar.
even assuming, Milord, what relief he can claim because he's a out and out invalid tenderer. Because Ronak, one line is Ronak very clear. Milord, if you are looking
She's,
along,
okay, so.
so is the Ronak, Milord, one line very important. I'm reading just one line.
By the time he finds out, if I may point out.
Yes, yes.
In the vernacular, my lord, of the NIT, whatever he is saying, the 15% deposit, my lord, in my humble submission, that is not mandatory, I have stated. Why?
See, I'm not
why-
on that.
Mal-
Madam, you see, the issue is this.
Mal-
According to you, respondent number 6 is Gopal Chandra Das. According to him, his name is not Gopal Chandra Das, it is Gopal Sarkar. Now, according to you, your answer is, his name is actually Gopal Chandra Das, Gopal Das, alias Sarkar.
Sarkar.
And you are saying this on the basis of the RTI information received by you at page 32.
32.
Now the translation of page 32 is at page 30. And nowhere has it been stated or translated by you that Gopal Das is Sarkar.
In fact, 2016 note sheet clear that Gopal Das
Whose note sheet is that?
it is standard authority.
And who are you?
I'm not he is there, my lord. From him I took it well. My lord, I found it 2000 note sheet clear. Gopal Das tender was rejected.
2016.
16.
Date?
23/12/2016 because of non-submission of earnest money. Clearly reflected. My lord, may I read it?
So tender rejected.
Gopal Das, Sri Narahari
Well,
Das,
is it Gopal Das or Gopal Chandra Das?
Gopal Das,
Gopal Das.
Gopal Das, Narahari Das, and Dhankanta Das have not submitted the call deposit.
Okay, 3 tenderers. And it was settled with?
The rest of the tender, Gopal is the highest bidder, being the amount of 5,000. The second highest bidder is Noni Sabda Das.
No, to whom was it settled? The settlement, the fishery. Okay, there's nothing left to decide. Then.
My lord, from 2012 to 16, as per their record, my lord, that he was not running the fishery. I just.
Who was not running the fishery?
The respondent number 6, he was not running
so?
the fishery, therefore, this is the reply given by government, therefore he is not a defaulter. Although a certificate has been issued by the but still on inquiry, they found that from 2012 to 16.
There's nothing here, madam.
And my lord, lordship.
You want to challenge this, you challenge it in a thing. What is this? Additional was, okay. Since lease was different as the amount paid by Gopal Sarkar alias Gopal Das. What about this page 36? From 2009, from 2012 to 2000, from 2009 to 16, who was the settlement holder?
That's what, my lord, I prayed before this court, let them produce those records who had deposited the revenue during 2012 to 16.
9 to 16.
12 to 16. And those records were called for on last occasion. my lord. 12 to 16.
It says 9 to 16, madam. Why you want?
12 to 16, because in the, my lord, this order passed by the government, they said that 12 to 16.
You please
Somebody,
look at page 36, madam.
36.
Don't. Why you get stuck only with one document? That document does not help you at all.
Therefore, 9 to 16. 9 to 16. Lordship may kindly peruse page 41, my lord, paragraph 6 and 7. Page 41, my lord.
41.
Yes, ma'am.
Yes.
Paragraph 6, as regards the statement made in paragraph 8 regarding defaulter, deponent begs to state that narration given by the impugned order regarding non-handling of number 69 Balashuti group fishery to the applicant is completely false and manipulated. Name of Shri Kaludas as introduced to have been run the said fishery from 2009 to 16 is incorrect and would be subject to production of records by the respondent. To that effect, the deponent begs to state that respondent may be directed to produce the draft money received from Shri Kaludas if at all he was running the fishery from 2009 to 16. So this record, they will-
Begin from the, here, my lord, record. And placing it before your lordship, in 2016, it's a fishery of Bola City Group fishery, 5 tenderers submitted tender.
We are not worried about 2016 onwards. We are only for the period of 2009 to 16. Who was the
9
salmon?
to 16.
9 to 16.
Oh, then this is the. It was 9 to 16, you know, that I did not hear. Not here.
that was
It is only in respect Bhopal Sarkar got the settlement in 2016 tender process. But the position.
But because of earnest, non-deposit of earnest money,
Gopal Das was,
it's 10 days
Gopal Das was rejected.
rejected.
And the non-deposit of earnest money because Gopal Sarkar was settled. Yeah. Now, what happened? From 16 to 21, they failed to hand over the position. Am I?
Who failed to position?
Government failed to hand over the position to Gopal Sarkar till 21. In 21, they handed over the position to Gopal Sarkar.
Why? His tender was rejected.
No, Gopal Das was rejected.
Acha, Gopal Das and Gopal Sarkar are
The
different.
two different people. And 2016.
But what about this letter by the DC saying out here Gopal Sarkar alias Gopal Das?
I don't know, because of your lordship order. Your lordship order is Gopal Das. Your lordship, therefore they put it Gopal Das and alias Gopal Sarkar. They referred it as a Gopal Das in the as a respondent.
Okay, so they have filed this. It was disposed of on the motion itself.
Itself. And therefore, everything.
No chance was given.
No, now, even then, today also they have filed it as Gopal Das. But
Yes, let us see the order again. When was the default period? As per his information says so, the number Balasuti has the lessee has paid total of census revenue to the government of Assam and is due. So from Gopal Chandra Das it is say. So Gopal Sarkar there is nothing. So according to them, madam, Gopal Sarkar is a different thing altogether.
But this repetition, Gopal Das is the partner, not Gopal Sarkar.
Correct.
Why he
So-
is appearing for Gopal Sarkar?
Because he's got the the fishery has been settled with him. Fishery has been settled with him. So you go to a civil court, madam, I think. Let them go to civil. Right. Heard Ms. P. Chakrabarti, learned counsel for the petition. Also heard Mr. M. Chetia, learned counsel for the respondent numbers. Three and four. Mr. R. Chetri on behalf of Ms. P. Sharma. This for respondent number 1 and 2. Who appeals for five?
Five government register secretary.
Registrar of Fisheries, who appeals? Huh? You don't even know for who you are appearing. You have not read even the cost title. Huh? Are you sure? You'll be five. Okay, 1, 2, and 5, huh? So there. Mr.
That's what talking about.
S. Kotoki appears for the respondent number 6. The petitioner's case is that the respondent number 6 has been settled with the 79 number Chatla fishery under the Kolgachia Revenue Circle for a period of 7 years pursuant to the NIT dated 1/10/2024. As the petitioner's bid was the highest, bid amount was the highest. While the respondent number 6 bid was the highest. As the bid of the respondent number 6 was the highest, while the petitioner's bid was the second highest. The petitioner's case is that as the petitioner is a defaulter,
Respondent, yes.
and as the respondent number 6 is a defaulter with respect to settlement of the Balai Suti group fishery, as has been reflected in the RTI reply dated 21/8/2024, issued by the Additional District Commissioner bracket Fishery, Barpita. The petitioner could not have been settled with the 79 number Chatla fishery in violation of the NIT dated 1/10/2024. Next paragraph. The petitioner's counsel submits that though this court, that though the petitioner had come to this court earlier by WPC 6787 of 2024 against the same challenge, again on the same ground. This court had disposed of 6787 of 2024 on the first day itself without the presence of the respondent number 6. By directing the circle officer Barpita to decide whether the respondent number 6 was a defaulter, as had been alleged by the petitioner, before finalizing the tender. Next paragraph. The petitioner's counsel submits that though the respondent number, that though the additional, this deputy commissioner bracket fishery has issued the order dated 30/12/2024 pursuant to the order dated 17/12/24 passed in WPC 6787 of 2024, holding that Gopal Das alias Gopal Sarkar cannot be considered as a defaulter, the respondent number 6, Gopal Chandra Das, is a defaulter. Full stop. Next part. Mr. S. Kataki, the learned counsel for the respondent number 6, at the outset submits that the 79 number Chatla fishery has been settled with Gopal Sarkar and not with Gopal Chandra Das. He submits. Just call for this record, just call for this WPC, call for this WPC 6787 of 2024. Just call for the records. 2024. It was disposed of on 17/12/2020. I want to see what the petitioner has, whose name he has reflected. Is it alias or not?
No, no, not there. Not there.
No. In the earlier writ petition.
I think Gopal Chandra Das.
Achha, no alias.
No, alive, no.
But I just want to check.
Oh, why not?
Oh, no. Then why did the DC out here say alias?
Because of your lordship order, Gopal Das. Actually, that's probably that confused that. Your lordship.
Okay.
Gopal Chandra Das, otherwise,
Okay, what have I said? So stop. He submits. He accordingly submits that. Huh? But who's the point number 6 again? He submits that Gopal Sarkar and Gopal Chandra Das are two different persons. He also submits that the mistake in the order, he also submits that a mistake appears to have been made in the order dated 30/12/2024, passed by the Additional Deputy Commissioner of Fishery, pursuant to the order passed in WPC 6787 of 2024. In view of the fact that the petitioner hearing has also reflected the respondent number 6 in the earlier writ petition as Gopal Chandra Das. While the fishery in question had been settled with Gopal Sarkar and not Gopal Chandra Das. That's all. Next, Mr. M. Chetya, the learned counsel for the respondent number 3 and 4, has produced the records. And the same shows that that one Gopal Chandra Das, Gopal Chandra Das? Gopal Chandra Das was the highest bidder pursuant to the NIT dated that for 2016. NIT dated dash. Dash for settlement of the fishery for 7 years with effect from 2016 onwards. However, as Gopal Chandra Das had not submitted his earnest money, the tender of Gopal Chandra Das had been rejected by the authority. He also, the Mr. M. Chetya submits that Gopal Sarkar and Gopal Chandra Das are altogether two different persons. And as such, the petitioner hearing, and as such, the respondent number 6 hearing, who is Gopal Sarkar, cannot be said to be a defaulter. Yes, cannot be said to be. What is the NIT dated? NIT? Huh?
19/11/2016.
Nine-
Earlier,
1911. And that note sheet was dated?
posted is 2012.
Okay, okay, that advertisement is dated 19/11/23, huh? 1911, NIT dated 19/11/23. No, 16. 9/11/16. Then note sheet is dated
23/12/2016.
23/12/23. Okay, that I'll put it later. Okay. And what about prior to 2016? Who was the settlement holder? Huh? Yes, ma'am. Anyway, Sarkar is not the issue, right? That's fine. Next part. So as the fishery has got nothing to say here. Next part. I have heard the last answer for the question. In view of the specific stand taken by the respondents number 1, 2, and 6, no, 3, 4, and 6, that Gopal Sarkar and Gopal Chandra Sarkar are two different persons, comma, and there being nothing to show in the records that Gopal Sarkar is a defaulter with respect to Balai Sutti Group Fishery, comma. This court is of the view that no case for interference with the settlement of the 79 number Chatla fishery with Gopal Sarkar has been made up. In fact, Gopal Sarkar has not even been made a party in this petition. Comma, though it has been alleged by the petitioner counsel that Gopal Sarkar and Gopal Chandra Sarkar are the same person.
Gopal Das and Gopal Sarkar are one and same.
Gopal Sarkar and Gopal Chandra Das are the same person. This court is of the view that even if we are to accept the stand of the petitioner's counsel, the same would require the leading of evidence in a civil court, so as to decide a fact, a disputed question of fact. However, in the facts of this case, there is nothing to show that Gopal Sarkar is the same person, having a different name of Gopal Chandra Das. In view of the reasons stated above, this court does not find any ground to entertain this writ petition. Accordingly, the writ petition is dismissed, with liberty being given to the petitioner to approach the civil court.
The findings of this court shall not,
Huh?
findings of this proceeding shall not affect.
If so advised. In the event the petitioner approaches the civil court, the findings and observations made by this court shall not influence the decision to be taken by the civil. The writ petition is accordingly disposed of. In view of the dismissal of the main writ petition, the I is also disposed of accordingly. Yes, what is the case?
May I please, Your Honor? My lord, this is a case. The petitioner is my lord, proprietarial firm having a IMFL off license to sell, my lord, liquor. Now, the challenge
I have
in
already
this
called for
repetition
it.
is,
Okay. Yes,
my lord, the challenge in this repetition is,
let us see the impugned order
yes, my lord,
and
before
the report.
my lord, I briefly state the facts so that your lordships can get, my lord, the, what is written, my lord, what is the.
No, no, it will be stated, it will be there in the impugned order. and the
Impugned
report.
order, my lord, is based on an inquiry report.
Let us see the report.
Yes, yes,
Where is the report?
yes. I
Page.
take your lordships to Annexure 7. This is the inquiry report, my lord. This inquiry report is purportedly by one Inspector of Excise, Bureau of Investigation, EO, Assam. Now he belongs to the Excise Department. Now this is addressed, my lord, to the Commissioner of Excise, Government of Assam, through the proper channel, subject, detailed report regarding
Of
inspection.
2000 or 22.
My lord, this is of 22. Dated, my lord, is in between, through the proper channel, dated Guwahati, 5th December 22. Now this reads as follows. Subject, detailed report regarding inspection of MS Nisha Wine Shop, Nalbari, Delhi Bazaar, Nalbari, Assam. Sir, with reference to the above, I have the honor to inform you that an inspection of IMFL of IE MS Nisha Wine Shop, Nalbari, Delhi Bazaar, District Nalbari, Assam, was undertaken by a team of BIEO officials on dated 24/8/22. During the inspection, the following irregularities were found. No departmental approval, endorsement of the agents and salesmen employed at the wine shop, i.e. Messrs. Nisha Wine Shop, Nalbari, Delhi Bazaar, Nalbari, to be found when inquired. The staff employed at the wine shop had informed that they do not have any official approval from the department. Neither the licensee had sought any approval prior employment of the salesman at the wine shop. In view of the above irregularities, the wine shop is liable for breach of following provisions. Now, they go to quote the provisions, my lord. Assam Excise Rule 2016, Rule 302. Name of salesmen and agents to be endorsed on license before employment. No licensee for the retail vend of any intoxicant other than number one, the licensee of a hotel, restaurant, bar club, or number two, a chemist or druggist holding a licensee or permit under the Act shall allow any person to conduct sale in his licensed premises or to carry any intoxicant on his behalf, unless the names of such persons have been previously submitted to the collector or to the subdivisional officer or the superintendent of excise for approval and endorsed on his license. This is my lord 302. So essentially, they allege, my lord, there is a violation of 302 in as much
So
as
what does 302 say? No license for the retail vend of any intoxicant other than so.
allow any person to conduct sale in his licensed premise or to carry any intoxicants on his behalf, unless the names of such persons have been previously submitted to the collector or the subdivisional officer.
So did you follow this? Have you done this?
Yes, my lord, I'm coming to that. My lord, apparently there is a violation of Rule 302.
So you did not comply.
Yes,
That's what I'm asking.
yes. Purportedly, there was no compliance, my lord, in that regard.
There's
Some-
nothing purportedly either you complied or not complied.
Yes.
That's all.
My lord-
Did you comply?
No, my lord, I'm
Yeah.
coming to my point, my lord. In fact, this is, my lord, here, your lordship is not required to adjudicate a factual dispute, whether there was
No,
compliance or not.
Mr. Council, it's
Yeah.
not a question of whether I am required to or not.
No,
I am asking you a question.
yes, correct.
Yes, I'm not on-
Correct,
So
correct,
you please answer my question.
correct, man. There was,
Okay.
on the day
Huh.
when the, my lord, inspection was carried out, apparently, my lord, there was no, my lord, identity card or there was no document
No, I'm not on that.
which could have,
I'm not on that. I am on whether you had submitted
Yeah.
any letter
Yeah.
to the collector or the subdivisional officer or the superintendent of excise
Yeah.
the names of your employees
Yes, yes.
for approval for selling your liquor.
That was, my lord, submitted. Annexure 4 series is
That is
there.
what I'm asking you. Where? Where is that?
Page 17, my lord.
Page 17.
Yes, Annexure 4 series is there. But, my lord, more
Page
than-
17.
yes, these are 3%, my lord.
This
I-
was issued when?
This was issued, my lord, 28/9/22, subsequent to, my lord, the inspection, apparently.
That is why that
Correct,
is.
correct, my lord. What I'm
Let,
trying to
let us, you see, let us be fair, let's be frank. I'm not asking you what's happened after a certain event. I'm asking you what's happened prior to a certain event. So
Correct,
let
my
us,
lord. My lord, I'm fair to your lordships on the date of inspection, my lord.
say that.
No identity.
Correct,
card.
that is what I
There
want.
was no identity card,
Correct.
and there was no endorsement at all. But, my lord, my respectful submission is, my contention is totally on a different premise.
Maybe, but let us, you
Correct,
see,
lordship.
whatever you are projecting,
My-
and the questions I ask pertains to a certain period.
Fine.
It doesn't talk about what's going to happen in 2020 or
Correct.
28 or 29.
Correct.
What has happened previously.
Yes.
Okay,
My lord,
then,
lordship is absolutely correct.
yes, then
The
next,
inspection was carried out on 24/8,
yes,
and the
that time you had
identity
nothing.
cards are on 28/9.
Hmm.
24/8 is the date of inspection, my lord,
Correct.
and the identity cards 28/9. Therefore, apparently subsequent to the inspection. This, my lord, is an admitted fact.
Mhm.
Now, so therefore, the, my lord,
So
allegation,
302 violated.
yes, 302 apparently violated.
Yes, 3010, 310.
310. 310, my lord, is in fact, it does not prescribe any punishment. It reads as follows. Licensee bound to observe excise laws, rules and conditions of license. The holder of a license, permit or pass shall be bound by the conditions thereof and shall observe all excise laws, rules and conditions of the license, all directions, prohibitions and rules be embodied in the conditions of his license, permit or pass or not, and all directions, orders and prohibitions contained in rules lawfully made under the excise laws of which he shall have received due notice. So 310 contemplates, my lord, that he will bound by the conditions of the license as well as, my lord, the rules and regulations. So this is a law which binds, my lord, the license holder to comply with the conditions of the license as well as the rules and regulations. Now 344, my lord, this may not be relevant because here it relates to punishment or penalty be recorded on the license. For the purpose of the present case may not be relevant. Any punishment or penalty imposed of a licensee without forfeiture of his license, whether awarded by a court or by a collector, under the act or rules thereunder, and any offence compounded by a license under section 76 of the act shall be recorded on his license. So there would be a, my lord, endorsement by the authority that, my lord, earlier, my lord, that punishment has been imposed. So this, my lord, is usually show that there was a, my lord, prior, my lord, penalty, or sorry, my lord, commissions or commission has been, my lord, made by him. Then your lordship will come to next page 23. My lord, this particular provision is relevant for me and which I will rely on.
Yes,
They have invoked section 58B. Under 58B, my lord, the fine have been imposed.
yes.
Assam Excise Act 2000 under section 58B. In any case, not otherwise provided for this act, willfully contravenes any rule made under section 84 or willfully does or omits to do anything in breach of any of the conditions of such license, permit or pass shall be punished in case of B with fine which shall not be less than 50,000 rupees, but which may extend to 5 lakhs rupees, and the convicting magistrate, lordship will kindly see, my lord, this expression, the convicting magistrate shall direct the offender to be imprisoned in default of payment of fine for a term which may extend to 6 months. So 58B, my lord, contemplates that in violation of, my lord, the rules and magistrate
my lord, will be empowered to impose a fine which may, my lord, go from 50,000 to 5 lakhs. Then, my lord, they have quoted Rule 492.
58
B.
B.
Yeah. Well, I'll come to the excise.
58 B of what? Assam Excise rules.
Assam Excise Act.
Act
Yes.
2000.
So why is it, it's a rule, it's at a
It's at page
section.
35, Your Lordship.
The violation, my lord, is under 302, it's of the rules. And the invocation, my lord, is under section 58B of the Act. So the power to impose fine is under 58. Then may I continue, my lord, the inquiry report?
Yes.
Then, my lord, they have quoted Rule 492, imposition of fine in case of breach of conditions of license or rules. This is not, my lord, applicable to me because here is not a case of breach of conditions of license. So thereafter, I take your lordships to, my lord, the subsequent.
But it says imposition of fines in case of breach of conditions of license or rule.
This will also come, forfeiture of deposit and cancellation of license in case of any breach of those rules or of the condition of the license, or in any case, any attempt by altering the capacities of the receptacles or otherwise deceive the officer in charge in gauging or proving either by the licensee or by a person in his employment, it shall be competent of the excise commissioner to impose fine upon him in lieu of cancellation of his license, a fine under section 76 of the Act. Here they have, my lord, invoked 58. That is why, my lord, I am saying this is not relevant for me. In view of violation of provisions of Assam Excise Act 2000, Amendment 2018, under section 58B, lordship will kindly take note of, the fine is liable to, the firm is liable to pay a fine of more than 50,000 extended up to 5 lakhs. However, in order to ensure compliance and to avoid likely prolonged litigation, in case of extreme permissible fine, we may levy a fine of 1 lakh of the firm. It is therefore requested that the request is to the additional commissioner that an amount of 1 lakh only or any amount as permissible and deemed appropriate may be realized from Messrs. Nisha Wine Shop, Nalbari, Delhi Bazar, with an intimation to this office. So basically, my lord, this is the inquiry report. So purportedly, my lord, the fine has been imposed for alleged violation of 302 under the rules, and thereby, my lord, section 58B of the Act, my lord, has been invoked to impose the fine.
Yes, so why can't it be done?
Yes, my lord, my respectful submission is 58B says this has to be done by magistrate. And apparently, the order at page 24, the impugn order, relying on the inspection report, has been issued by the additional commissioner of excisemen. And he is not a magistrate of second class. So therefore, out and out, this order is without any jurisdiction. Page, my lord, 24. I take your lordships, my lord, to the Excise, my lord, Act. Then, my lord, things will become more clear. 58B, my lord, I'll take your lordships to first 58, then 58B. Then I'll come to the, my lord, relevant provisions, which says that the prosecution under this Act has to be, my lord, tried by a magistrate, not below than second class, my lord. So this order is without jurisdiction. So if your lordship comes to 58, breach of rule or condition of license, whoever being the holder of a license, permit or pass granted under this Act, or being in employ of such holder and acting on his behalf, A is not, my lord, relevant, but that's why such, I'm reading it out. Here B is invoked. Fails to produce such license, permit or pass on the demand of any excise officer or of any other officer duly empowered to make such demand. So on demand, when he, my lord, fails to produce the license. Now B is relevant for the present purpose. In any case,
not otherwise provided for in this act, willfully contravene any rule. This is one, my lord, made under section 84, or willfully does or omits to do anything in breach of any of the conditions of license. This is with regard to license, my lord, permit or pass, shall be punished in case of A, that is, my lord, the first clause A, with fine which shall not be less than 10,000 rupees, but which may extend to 50,000 rupees. And in case of B, B means, my lord, when there is a violation of the conditions of the license, or when there is a breach, my lord, of the rules, then what is the fine? With fine which shall not be less than 50,000 rupees, but which may extend to 5 lakhs, and the convicting magistrate shall direct the offender to be imprisoned in default of payment of fine for a term which may extend to 6 months. Now we have to read 58, my lord, with section, my lord, 69. I take your lordship to 69. If your lordship comes to 69, ma'am.
Yes.
69 relates to initiation of prosecution. No magistrate shall take cognizance of an offence punishable. A is not relevant, my lord, because we are not concerned with these provisions. Your lordship will come to B. Under section 56, 57, 58, 58A or 64, except on the complaint or report of a collector or other officer empowered under section 42, subsection 2 to investigate the case. Then your lordship will come to 69(2). Except with the special sanction of the state government, no magistrate shall take cognizance of any offence punishable under this act unless the prosecution is instituted within 6 months after the commission of the offence. So there is a bar also, man. Then your lordship will come to 70. The magistrate who is empowered to try. So essentially, my lord, there has to be a trial. There may be a summary trial, but the magistrate has to, my lord, determine that an offence has been committed under this act. And it has not been, my lord, the power has not been conferred on the officers of the department. It is the magistrate, my lord, who can take cognizance, my lord, and, my lord, inflict the punishment of fine. 70 says, magistrate empowered to try case under this act, offences under this act shall be triable only by magistrate exercising powers not less than those of a magistrate of second class. This makes it absolutely clear. So, my lord, in my respectful submission, this is a case of total without jurisdiction, man. The imposition of fine by the departmental officer is absolutely without jurisdiction. The act does not confer any power on them. They ought to have, my lord, made this, my lord, presented this complaint before the magistrate to take cognizance and thereby proceed against me, man. And your lordship will see the impugn order, page 24. Acting on the inquiry report, my lord, the additional commissioner of excise has passed this order to take necessary action as per Assam Excise Act and rules. My lord, I am reading it out from additional commissioner of excise to deputy commissioner, subject inspection report submitted by BIEO. With reference to the subject cited above, I have the honor to enclose herewith 2 numbers, detailed inspection report of the following IMFL off license as received from Superintendent of Police, so-and-so, 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 all dated 5/12/22, and request you to take necessary action as per Assam Excise Act and rules and submit action taken report at an early date. My lord, I am representing the, my lord, wine shop at serial number 2. I'm not representing others, my lord. Messrs. Nisha Wine Shop. So this order would be, my lord, confined to only 2. Then your lordship will come to the next impugn order at page 25. Pursuant to this order of the additional commissioner, the deputy commissioner, my lord, proceeds to direct, my lord, to deposit fine of 1 lakh within 15 days. To the licensee, so and so, deposit of fine for violation of Assam Excise Rules 2016. He has directly come to the conclusion, my lord, without any trial. Reference, Commissioner of Excise, Office Letter number so and so, dated 17 December 22, enclosed letter so and so. You are hereby asked to deposit the fined amount of 1 lakh only as determined by BIO as per letters enclosed, which is self-explanatory. Fine amount should be deposited within 15 days. Well, this is what has happened.
Yes.
And the enquiry report, my lord, the letter of the additional commissioner and the, my lord, this particular order of the deputy commissioner are, my lord, put to challenge. We are asking for setting it aside, man. And so far as, my lord, the affidavit is concerned, my lord, this particular issue has not been addressed. There is no mention, there is not a single whisper that the officers, my lord, has the jurisdiction, my lord, to pass this order. And when this honorable court was pleased to issue notice on the very first day, my lord, interim order was passed on this ground that it is only the magistrate who is competent. Despite such, my lord, that plea has not been taken. Completely silent, my lord, the affidavit. So this is my respectful submission.
Lordship, given or take, whether order is passed rightly or wrongly, there is a violation of the rules, Your Lordship. That's been established. That's completely established. So right now, the petitioner is saying that at 58B, the magistrate has the authority. So my lord, kindly take some excise rule, Act 76, Your Lordship.
Huh?
76.
Section 76,
Section
Rule
70,
76,
Assam
what?
Excise Act 2000. Assam Excise Act.
Section 76.
Page 41.
Yes.
It says that the offences under this act, except under subsection 1 of section 3, section 54 and section 50 and 55, shall be compoundable.
Compoundable by whom?
Compoundable, that's any person license holder who is reasonably suspected of having committed any offence under sections section 53(1), 50, 55 of this act may apply to excise commissioner or a collector for compounding of the offence before he is convicted.
So 302 is not here.
302 is not here. So
No.
he's saying 58B, convicting, but he's exposing himself to a trial, Your Lordship.
Correct.
He's exposing him to a criminal offence.
No, you just tell me. You see, compounding of offense. This offense is under 302.
302, but
It is not a offense under 53 or 54, 55.
54, but this inquiry report says that in view of provision of the Assam Excise 2000 amendment under section 58B.
Correct. So 58B also is not included.
58, so 58B is not included. So this means 58B is compoundable, Lordship. The offense under the section under section
shall
1
be
of section
compoundable.
53,
Ah.
except under subsection 1 of 53, 54 and section 55 shall be compoundable.
Alright, okay, it shall be compoundable.
Shall be compoundable. So though
It
this
shall be compoundable by whom?
is compoundable by the excise commissioner or the collector. The excise commissioner or the collector has authority to compound it.
But who has got the, before compounding it? This is a question of not compounding, this is a question of,
Jurisdiction.
no, this is a question of imposing a penalty.
Imposing a penalty.
So who can impose a penalty?
The penalty as per 58B is the magistrate, Your Lordship.
That's
The magistrate.
If it's a
Rightly or wrongly,
magistrate,
magistrate is there.
if a magistrate is the one who can impose a penalty. And if that is the case, then who has imposed the penalty here in this case?
The deputy commissioner, not the party. He has
So-
imposed.
So can it be done?
That cannot be done.
That is, if that is your case, then everything goes.
Everything, but thing is that since he's already operating a shop, he has not paid the fine. So thing is that let us set aside this order. Let us set a fresh lawsuit regarding this. Because since already a violation is there, 302 is there. 302's violation is there.
There's no
Please
bar,
attend.
there's no
There's
bar
no
for
bar
you,
for us.
there's no bar for you to take it up as per law.
We'll take up the as per law, Lordship. Because the inquiry process is under 58B. Under 58B is the convicting magistrate. Since we have not issued any excise case against him, any trial against him, the deputy commissioner issued this notice. So right now, if this is set aside, we'll start afresh, we'll start the criminal proceeding.
Let them do whatever they like, they do, Malot, like, do, Malot, they want to do. But so far as, Malot, my respectful submission is, there has to be a determination, Malot. That
Correct, no,
there
that-
is a, Malot,
that-
violation of the
that-
rule.
okay, we have heard.
Now, they have jumped to the conclusion on the basis of the inquiry report that there is a violation. Who will determine, my lord, there is a violation? And number two, I have stated, my lord, in my petition,
No, there has been a violation is clear. It's clear. From your pleadings also it is clear. The only thing is that it is not been done by the magistrate. That,
no, my lord, lordship will kindly see, I have stated that application was submitted before the authority. Now, if those, my
when
lord,
did you submit your application?
that date is not there. I have, your lordship will kindly see that application office, my lord, application is
Page
not.
17.
No, I have stated in my paragraph, my lord.
Page 17, there is.
I have stated in my paragraph, your lordship will kindly see paragraph 3. Your lordship will kindly come to
Page
page 5.
17. This is the,
This is the ID card and issued on
These are-
28/9/2022.
No, maybe, but when was it applied for?
Yes, my
We
lord,
did not submit it.
I tell your
We
lordship, my
did
lord,
not, we did not have any record regarding the application.
Anyway,
if there is
anyway,
no,
why
my
should
lord,
why should I go into
yes, my
those?
lord, this is unnecessary. And
No, no,
our, my
but-
lord, in fact,
No, Mr. Counsel, look. The only thing that has to be decided here is with regard to the competence of the authority who had issued that penalty order.
yes, ma'am,
That's all.
that's all.
So once that goes, they can take it up afresh as per this, as per their
It is up to them,
discretion.
ma'am.
That's all.
But my lord, he's asking for a direction from this honorable court that they will start afresh.
I'm not asking for direction.
Only-
We'll start afresh,
Yes.
your lordship.
They are at liberty, they can do what they, my lord, want to do in terms of the, my lord, the provisions of the act and the rules, my lord.
Correct. Heard Mr. H.K. Talukdar, learned counsel for the petition. And Mr. R.R. Gogoi, learned counsel for the
Excise Department.
Excise Department. The petitioner is aggrieved by the
Start from page 22, my lord.
by the detailed inquiry report. By the inquiry report
Inquiry
They-
report, page 22, my
dated
lord.
5/12/2022, comma. The letter dated 17/12/2022 issued by the Additional Commissioner of Excise, comma, in charge. Assam, and the letter dated 6/1/23 issued by the Deputy Commissioner Nalbari, asking the petitioner to deposit an amount of rupees 1 lakh as determined by the inquiry officer in his inquiry report dated 5/12/2022. Next panel. The petitioner's basic challenge to the above three documents is that the basic challenge to the letter dated 6/1/23 issued by the Deputy Commissioner Nalbari is on the ground that the Deputy Commissioner has got no competence to issue such an order, keeping in view Rule 302 of the Assam Excise Rules 2016. Huh?
Section 58B, my lord, read with 69 and 70.
No, but the 302 will come first.
302,
Naturally. Read with Section 58 bracket small b and Section 69.
And 70.
The comma, section 69 and 70 of the Assam Excise Act 2000. Next panel, you're right. The facts of the case in brief is that during inspection of the petitioner's IMFL off shop bearing the name MS Nisha Wine Shop on 24/8/2022. It was found that the agents/salesmen employed by the petitioner to sell the alcoholic and the alcoholic products, comma, no departmental approval / endorsement for employing the salesmen / agents had been sought for from the excise department. First, the inquiry report thereafter came to a finding that as the same was in violation of Rule 302 of the Assam Excise Rules 2016, here and after referred to as the 2016 rule, comma. The petitioner was liable to be punished with a fine which was not to be less than rupees 50,000. Comma, but could have been extended to rupees 5 lakh. As the inquiry officer had recommended that a fine of rupees 1 lakh be realized from the petitioner for not seeking prior approval for employment of his agents / salesmen for running the for selling liquor products. Whatever I said is the last sentence. Full stop. Full stop. As such, not for the petition. Okay, as such, comma. Next. Pursuant to the inquiry report dated 5/12/22, the additional commissioner of excise, Assam, wrote a letter dated 17/12/22 to the deputy commissioner Nalbari, requesting him to take necessary action as per the Assam Excise Act and rules and submit an action report thereafter. Next paragraph. The Deputy Commissioner Nalbari thereafter issued the impugned letter dated 10/1/23 to the petitioner requesting him to deposit rupees 1 lakh as had been determined by the inquiry officer by inquiry report dated 5/12/2022.
The deputy commissioner letter is 6/1/20.
But the signature is of 10/1.
Correct.
Next para. The petitioner's counsel, what? Huh? The petitioner's counsel submits that a reading of Section 58B along with Section 69 and 70 of the Assam Excise Act 2000 clearly goes to show that the penalty to be imposed in pursuant to Section 58B can only be done by a magistrate, and that too only after a trial has been conducted by a magistrate not less than a magistrate of second class. He submits that as no trial had taken place before a magistrate of second class pursuant to section 58B of the Assam Excise Act 2000. The impugned penalty order dated 10/1/23 issued by the Deputy Commissioner Nalbari should be set aside. No, you just say not 10/1, you say before that, you say letter dated 17/12/22 issued by the Additional Commissioner of Excise Assam and should be set aside. Next paragraph. Mr. R.R. Goy, the learned counsel for the Excise Department, what submits that he does not have any what quarrel with the proposition of the petitioner's counsel. What?
Lordship, that fine has been imposed under section 76, that may be recorded also, because as per instruction 76, it says the compounding of them, though
Submits that though he does not have any quarrel with the submission made by the petitioner's counsel, that the penalty could have been imposed only by a magistrate, second class,
Instead of saying that, well, instead of saying that, Lordship will say that my submission is that they are without jurisdiction. And if I say, my lord, that it can be only imposed by magistrate, my lord, then, my lord, it
That
will
was
go
his
against me.
assumption,
Your lordship's, my lord, reading, my lord, they will take in a different way. So
you
my,
take a different way, we'll go as per.
you may
rules and
go,
regs.
my,
We
this is
will
my
go, your
submission
lordship.
before the honorable court, that I say that you don't have any jurisdiction.
So who has the jurisdiction? According to you, the magistrate has the
No,
jurisdiction.
instead of recording that, my lord.
Why should I not record what you
It's
have
up to
said?
your lordship's, my lord. This is
I
my request.
cannot,
No,
you cannot,
no, this is my
speak-
request, my lord. Your lordship can.
you see, your request, I am not
Lordship
going, I am going by what you are submitting.
Absolutely.
I
I
cannot
withdraw
do
this,
that.
my lord. I withdraw.
So what have I said? After a trial, the penalty that has been imposed can be compounded by the respondent authorities under section 76 of the 2000 Act. Make it here, earlier make it here and after referred to as a 2000. So what? You're saying this because you want to compound it or what?
If he's asking for, asking for an order from a magistrate, we'll go by it. We were here for the compound, we were giving a simple way, now he wants to take a long route, so we'll go by it.
No, but then when the penalty cannot be
Goes
imposed,
by deputy. That's
where is
true.
the question of compounding?
Yes, that's true, then that's a,
And you're right. I have heard the learned counsel for the party. Yes. Section, rule 302 of the 2016 rule, section 58B. This is section 58, 69, and 70 of the 2000 Act states as follows. But how does 58B come into play?
58B comes into play.
How? It says that in any case not provided for in this act,
My lord.
willfully contravenes any rule.
No, 58 comes, if your lordship comes to 69, 69 makes it clear. No magistrate shall take cognizance of an offence punishable under section 56, 57, 58. And they have invoked 58. My lord, authorities
Just a minute, just a minute.
have invoked 58, my lord, and thereby they have.
Being the holder of a license.
If your lordship comes to 84, my lord, I take
Yes.
your lordship to 84.
So
This will make it clear, my lord.
Make it 69, 70 and 84.
84 is the power to
84.
make rules, man. 84 power to make rules. So any rules made under 84 is violated. Then invocation of 58B comes into play, man.
Correct, look at that. A reading of, next para, a reading of section 58B. Comma 69 and 70. And section 80 of the 2009. It goes to show that a breach of any rule made under section 84 or omits to do anything in breach of the license shall be punished so it appears that they can impose 10,000 to 50,000 upon me
Hello?
as per 58B.
58B.
58B, then A, that small a. And
Yes. Small a, my lord,
Yes,
relates
that-
to. that
small a
means-
will relate to the rules made under 84.
No, small a is, my lord, 58A. Your lord,
58A, that-
58A, my lord, fails to produce.
No, I'm not on that.
My lord.
In 58B, there's another A and B
Yes.
inside.
That A is with fine, which that fine is for the subclause A also.
That is what I'm
Acha,
trying to
that
say.
is its
That is
subclause.
what I'm trying
Ah.
to say. This relates to clause A.
A clause.
Okay.
The clause A relates, my lord, to non-production of the license on demand.
That fine is less than 10,000, but
Okay, what have I said? With a fine. As per the decision made by the convicting magistrate. after a who should not be less than a magistrate of second class. And that too after prosecution is initiated under section 69. In the present case, the provisions of 69 and 70 have not been followed. While passing the impugned order dated 6/1/2022. Now, impugned letter dated 17/12/2022 by the Additional Commissioner of Excise and the order dated 6/1/23 issued by the Deputy Commissioner. Now, in view of the above reasons, this court is of the view that the respondents, the Additional Commissioner of Excise and the Deputy Commissioner Nalbari did not have the power to issue the said directions for recovery of rupees 1 lakh from the petition as penalty. Pursuant to the letter dated 17/12/2022 and the order dated 10/1/2023 respectively. Consequently, the letter dated 17/12/2022 and the impugned order dated 10/1/23 is hereby set aside. I'm not, the inquiry report will remain. That is only a recommendation.
Correct.
This court is,
So far as petitioner is concerned, there are others also. Letter
comma,
dated
insofar as it relates to the petitioner hearing. The inquiry report is not being interfered with by this court, as if those are questions as the contents of the same pertains to questions of facts. And as the penalty sought to be imposed therein is only a recommendation.
Deeply overlooked.
It does not have any binding effect on the competent authority to decide on its own. That's all. Huh?
This are fresh.
The written petitions accordingly disposed of. Sure. Right? Item? What is it?
You said fishery
It's also
settlement.
relates to fishery settlement.
I thought we finished.
One is finished.
I thought this is a different one.
Different one. Same allegation defaulter, government file affidavit.
Out here, name, no problem with name.
No problem.
Okay, so you are with regard to,
Yeah,
so out here, there was no, the earlier writ petition, didn't know.
Okay.
So, the respondent number 6 is the H1.
Yes,
You are H2.
I'm H2.
And your case is that he is a defaulter. Where is the proof?
But the same, the bucket as the RTI information.
Let us see.
Page 27, man.
27. What is happening? From 20 is jumping to 31. It is I. It is I will the writ petition. Oh. Page 27.
Is the translation?
Pranav Kumar Das. Pranab Kumar Das. Has paid to the government as revenue with the bill censor. And is due to be paid.
Yes.
Yes, some 20 lakhs is due to be paid by.
That's a difficulty, my lord. The fishery of that fishery was settled with me on 25/7/23.
Just a minute. 25,
7,
7, 20.
23.
Huh.
And the settlement order always from the 7 years from the date of handing over possession. Here in handing over of possession was on 15/9/2024. 15/7/24.
15, 7, 24.
How can it be 10 lakhs defaulter, madam? 15/7/24 and today is.
And this letter is of 21/8/24. So within 1 month, how can he be a defaulter for 10 lakhs?
10 lakhs, my lord.
It is provided by the deputy commissioner.
Now, another thing. This NIT is dated
NIT dated, my lord, 1/10/2024.
1/10/24. NIT is 1/10/24. What is this 25/7/23?
25.
720.
7/23.
That
Huh?
handing over possession.
No. Handing over position is 15/7/24.
15/7, my lord.
Why do I have this 25/7/23?
25/7. 25/7/23. 25/7/23 Accra bill.
Huh?
It's a different fishery.
Okay.
That was settled by the government on.
So that has nothing to do with you.
Nothing, because they alleged that I am
You
defaulter.
were settled with this fishery when? Settlement order.
My settlement order dated, my lord. On 8/1/25.
8/1/25. Possession prior to settlement order.
That relates to, my lord, Accra bill, where they allege
Acha, you are a defaulter.
I am a defaulter, my lord.
Okay. So okay. This your settlement order right now is 8/1/24.
8/1/25.
And they're talking about the Accra.
Accra.
Accra bill. Okay, Accra bill. For that, that was settlement order was 25/7/23.
And handing over possession on 15/7/24.
15/7/24. And for the present case, what is the bill? What is the NIT? NIT is the page.
NIT at
17.
page 16, my lord.
Page 16. 1/7/24 settlement order 8/1/25.
25.
And possession?
Possession on, my lord. In this case, my lord. Possession.
Because of interim order.
Because of there is a interim order, formal possession was not handed over.
Acha, so group fishery, no possession.
Possession was not handed over.
Okay.
Formal.
So it is with regard to Accra bill
Yes.
that Accra bill settled with you on 25/7.
7.
Handing over on 15/7, how can it be?
You know, handing over by the circle officer.
Handing over prior to settlement order.
No, my lord. Handing over in 24, my lord.
I should finish.
15/7/24. Settlement order 25/7/23, my lord. Ending over on
And the RTI application is of 21/8/24.
28/1/8/24. Prior to tender notice.
Huh?
Prior to tender notice.
No, no. It is RTI.
RTI. Oh,
RTI is 28 or 21/8/24.
21/8.
now here another point is, my lord,
So for how, what is the defaulter will be how much? Why should defaulter of 20 lakhs, 65,000?
where from, my lord? The government affidavit is clear, my lord. Where from? Government file.
So what is this, who is this person who has given this additional district commissioner fishery?
No, they should be held responsible. In creating lot of problems regarding what it. Because settlement was in 23, he cited by default prior to 23. Your lordship kindly have a look on the
Correct, revenue with effect from 2021, 22 till 24/25.
Milord, my
And-
settlement is 23
Settlement is of 25/7/23.
and position was handed over 24. And this fellow, Milord, as
Well,
per
yes, what does the note say?
note record was not called.
So we have filed affidavit, my lord. Yes, yes, yes. There is no default trial at all because my lord,
There is no default.
yeah, because he has the time to pay till 25/6/2030.
Who has given this letter? Maybe we should call the officer here personally
My lord.
with the records. Huh? This government of Assam district Barpeta fishery branch. Who is this additional deputy assistant commissioner?
Additional.
Additional district.
As additional district commissioner. Let him come.
Very unfortunate. Misleading everyone. When my settlement was 23 and he is giving ADR prior to settlement, 21, from 21 onward. There's a look. Look,
And this advertisement for this Akara meal was when? You don't know.
I don't know, Milord, because that was the 23 settlement.
You were the settlement holder.
Settlement holder. And here is also, Milord, the petitioner failed to deposit on it. Security money. As required under the conference.
Out here, petitioner failed to deposit.
Yes, Milord.
And in the earlier case,
Same thing, Milord.
you did not deposit earnest money in the earlier
was
case.
not
Huh?
Earnest money not deposited as per the record.
Oh my God, in the earlier case also,
Yes,
that I've got
I
to
checked
mention. Leonardo, in the earlier petition, petitioner did not submit earnest money. That has to be mentioned. So as per that, Ronak case,
Yes,
they could not make any challenge to your.
yes, that is misplaced.
Here also.
Any judicial relief at the yes of a
So basically, the tender is, his tender has been rejected.
rejected.
Petitioner's tender has been rejected. Madam,
Well, here I don't know, records have not come. madam. Here
no,
I'm
no,
not sure.
madam,
They have sent,
once,
but
see, I'm asking you, have you submitted the earnest money?
No.
Malad, as per their.
You don't know that. Selective
Because
amnesia.
without going to the records, Malad, I'm.
No, madam, this is your client. You know everything about them, what they eat for breakfast, but you don't know anything about yourself.
Yes, I have
No,
read
no,
the cooperative statement.
On the previous case, I have myself gone through the statement provided by the government, because only on the basis of the statement made by my client, I don't want to make any submission before this, in these fishery matters, Malad. I find them
No,
very,
no, madam.
therefore,
Oh, you call your client, we'll take it up at 2. You call your client,
they're in Borpeta,
ask him, huh?
they're in Borpeta.
Madam, there's a thing called mobile phone.
Oh, I'm sorry, calling, okay.
Milord, I have annexed the comparative statement, Milord.
No, you see, when you make a case, you have got to know your own case first. So the question that this court has put to you is whether you have submitted your earnest money along with your tender.
Well, when I said in my application, reply is that the deponent denied para number 6 as misconceived.
Without answering, no answer.
No answer.
So
This
you,
is the statement on oath, my lord.
misconceived.
We are wait for extension of the interim order, that's all, my lord.
I'm going to set it aside. I'm going to probably dismiss your writ petition. Unless you can satisfy this court by 2 o'clock that you had submitted earnest money along with your tender. You take that yes and no. If you say yes, you have submitted, then then I will call that officer with the record, and I will record your statement that you have paid. And if you have not, if you have told a lie to the court, then it will be very, then it,
Never do.
that will be very
That I'll
strict
never do.
action. Contempt will be taken up. At 2 o'clock. At 2 o'clock, let her take instructions. You just over phone whether you have earnest money paid or not. $21.
Supplementary. money. Listed for orders, my lord, but the pleadings are complete. Ready for disposal.
Okay, you all are ready?
I'm ready. It's a tender matter, my lord, where I am the L3 bidder.
L3,
L3.
petitioner is L3.
L3.
Mr. Bhattakur, you have what?
Sunal Foreman.
Yeah,
He is the L1 bidder, my lord.
private respondent.
Private respondent. There are two private respondents,
R4 is L1.
my lord. And
L1,
R5
who
is
is
L2.
L2? Huh?
L2 is not represented by the notice is served. There is an office note, my lord.
R5.
R5.
R5 is L2.
L2.
So, you are challenging both L4 and L5.
Yes, ma'am. On the ground that, man, the rate at which it has been given, man, it violates the Minimum Wages Act, PF Act, and the ESI.
Just a minute. Violates Minimum Wages Act,
My lord.
then what else?
The PF Act,
Huh?
Provident Fund Act, madam.
PF Act and
The Employee State Insurance, ESI Act.
ESI Act. What is the Minimum Wages Act year? 19?
Minimum Wages Act is 1948, madam.
Then PF Act
1952,
and
ESI Act is 1948.
yes.
Now, my lord, the tender specifically provides, it's a tender, it's a cleaning contract, my lord, of the railways. Service contract, my lord. The tender specifically provides that you have to comply with these acts, my lord. May I take your lordships to 132, my lord, page.
Page 132. Yes.
There is a chart, my lord, point number 7.
Yes.
It's a manpower-based contract, my lord. So you have to comply with the minimum wages while quoting the rate. Non-compliance will result in rejection. my lord.
So you are a manpower supplier.
Manpower. So the basic issue here is, my lord, the monthly wages which an employee receives, my lord, the monthly wages, to arrive at the daily wages, my lord, whether that figure will be divided by 26 or by 30, man. That is the simple issue.
No, so one thing I want to know is when you pay an employee, your employee, you have to pay him for the working days also and for the holidays also?
Yes, if he is a monthly rated worker.
If he is a
If
monthly
he is a monthly rated worker.
rated worker. Now, in the case at hand, are we dealing with monthly rated workers or some other category of workers?
Required to deal with both, my lord. Why I am saying?
So let us go one by one.
Yes.
So there are monthly rated workers and what workers?
Daily rated workers.
Daily rated workers. Now, let us go to monthly rated workers.
Madam,
Monthly rated workers will mean for the whole month.
will be for the whole month.
So that means you have to be paying them for their holidays also.
Yes.
So in that case, 1 month will be 30 days.
1 month will be 30 days.
So 1 month, so and then if you are going to pay them even for their holidays, say if it's a lump sum, you're paying say 3,000 for the entire month, it will have to be naturally to be divided by 30 days.
No, madam, that
Because
is,
because we are paying them even for their holidays.
no. The minimum wages which the government fixes, madam, it is calculated at 26 days, but it includes the holidays.
What do you mean?
It is because what I'm saying, madam,
Okay.
if I am paying him 30,000 per month, madam, his daily wages will not be divided by 1,000, madam. It will be more than 1,000.
Hmm?
Ultimately,
If
I'm just giving an example. Ma'am. See, suppose I am paying an employee 30,000 rupees a month. So if he daily, if we have to calculate the daily wages, madam, daily wages will not be 1,000, madam. It will be something more than 1,000.
no, for monthly rated workers, you mean.
Monthly rated, madam. Our employee may not work for a month, madam. Suppose it.
But there's a thing called monthly rated workers
Right.
and there's a thing called daily rated workers.
Yes,
Let us assume that the monthly rated workers work for a month,
month,
inclusive of the holidays.
madam.
Okay, inclusive of the holidays, meaning to say that he doesn't
Sundays,
work,
madam.
he doesn't work for the Sunday, but his salary has to be given even for those days he has not been working. Correct?
Yes.
So now you give him a money lump sum in a lump sum manner.
That is an
That will-
assumption, but I have to comply with the minimum wages act. Per day basis, I have to pay him something
Yes.
to comply.
So it is on the basis of the minimum wages act.
Yes.
Now, so you give him a lump sum, and if you're going to give him even for his holidays, why don't you subtract it by or divide it by 30?
No, it is by 26, the minimum
Why?
wages rules itself provide, madam.
Okay, fair.
So that is the basic issue, madam.
Okay.
Now, what happens?
Let us see the rule.
Yes. Even the ESI rules provides the same one. It is the minimum wages central rules, madam.
Let us see. Wait,
Page, madam. Match, madam.
which section?
Rule 23. Sub rule 4. How the daily wage is to be arrived at, madam.
Yes.
An employee, Lordship has got it.
Yes,
An
yes.
employee shall be granted for rest day wages calculated at the rate applicable to the next preceding day. And in case he works on the rest day and has been given a substituted rest day, he shall be paid wages for the rest day on which he worked at the overtime rate and wages for the substituted rest day at the rate applicable to the next preceding day. Provided, madam. Provided that where the minimum daily rate of wages of the employees as notified under the Act has been worked out by dividing the minimum monthly rate of wages by 26. So the daily rate of wages has to be divided by the monthly wages by 26 to arrive at the daily rate of wages. It is so in the Payment of Gratuity Act, even in the ESI Act, man. Lordship knows in the Payment of Gratuity Act, when a man retires, man, the total emoluments, man, is paid by multiplying the 15-day salary, which is arrived at by dividing the monthly salary by 26. That is section 4 of the Act. And even in the ESI rules, if I may show the Gratuity Act, man, section 4. ESI is there, man, the ESI rules, the ESI central rules.
Which rule?
ESI central rules 1950.
Which rule?
Rule 1B. 1 capital B.
Yes,
Average daily wages during a wage period means in respect of an employee who is employed on time rate basis, the amount of wage which would have been payable to him for the complete wage period had he worked on all the working days in the wage period, divided by 26 if he is a monthly rated, 13 if he is fortnightly rated, 6 if he is weekly rated, and 1 if he is daily rated. That is the average daily wages. Now, while notifying the minimum wages, my lord, it is not notified on a monthly basis. It is always notified on a daily basis. Now, the error which the railways have done is here, my lord, they have taken the monthly daily wages, my lord, multiplied it by 30. Because lordship knows, my lord, under the Provident Fund Act, there is an upper ceiling of salary. Even if you are getting 20,000 per month, the PF will be deducted only for 15,000 at the rate given. If the employee works for the entire month, if he is getting 50, if it is taken as 15,000, whether you divide it by 30 or 26, my lord, the net figure remains the same. He does not get more than 1950 per month as PF. But if he is working for 10 days, my lord, the correct calculation is that the PF, daily PF is 75 rupees as per the minimum wages which has been notified. But the railways have calculated it as 65. Now, lordship will see, in the present contract, my lord, I have to run the contract for 30 days. An ex-employee, suppose an employee X, I cannot make him work for 30 days. I have to give him the rest as per the minimum wages. Now, those 4 days, Sundays, the rails will run, the cleaning contract will go on. So for those days, I'll have to engage someone extra. That person will not be working for 26 days or 30 days. He'll work for something less than that, my lord. So there the difference comes. Suppose a person works for 10 days. The PF for that person is 750 rupees, which I have to pay as per the Act. Railways have calculated is at 65. As a result, my lord, the L1 and L2 rates are below the minimum wages, my lord. That is my whole case. I can now demonstrate from the records, my lord, that in an earlier contract, they had correctly taken out the figures, calculated the figures. But here, they are insisting that no, it is for 30 days. In their own contract, they do not deny. They say in the affidavit that that document is not relevant, but they do not deny that it is from their own contract, a separate contract. May I take your lordship to that now?
by the way, you're for who?
Oh, that's another phone.
And you're for? And what is your case?
Kindly see, here is the case, my lord. The employer has to pay the contribution for the whole month, my lord.
Correct.
But so divided by 30, my lord.
But what about the law?
No, my lord, kindly see, my lord. The Provident Fund Act, my lord. It pays for, my lord, basic wages, my lord.
Where is the Provident Fund? I don't have that. Yeah, Lord, he's relying upon the pay, minimum wages act.
Well, multiply by 26, my lord.
Multiply by
26.
divide
Divided by
30.
30. Because he has to contribute for the whole month, my lord.
He's going to pay the PF for the whole month.
Whole month, my lord.
EPF. But prior to that, may I just point out one thing? If your lordship kindly takes up page 157 of the writ petition.
Yes.
This is the calculation shown by the railways. This is also reflected in the minutes of the tender committee. This is a communication made to me when I raised the grievance. If your lordship sees let us take only one example, man. The unskilled laborers. The daily rate is 655.
Yes.
PF contribution, they are calculating at 60 plus 5.
Yes.
ESI, they are calculating at 18.45. This they are dividing by 30, man. There is no dispute on that. Now, Lordship comes to that serial number 5, my lord. This is the daily wage, according to them,
Yes,
738.45.
yes,
Now, admittedly, in column 7, they say that cost is 26, that is X minus Y, that is column 5 multiplied by 26. So if that figure monthly comes to rupees 19199.7, my lord.
just a minute. Cost is 26 into
26 days.
XY.
XY.
Where is Y?
Y is the total number of column number 6, man, serial number 6. So monthly wage, as per the calculation of the railways, is 19199.7, my lordship. May kindly make a note.
From where do you get that
But
one?
multiplying 738.45 by into 26
Comes to
19,199.7.
19,100
99.7. This is
for
when
30
the
days.
my lord,
For 30 days.
for 26 monthly.
30 days.
26. They are saying, admitting that when you make the payment, you have to make for 26 days. But when you arrive at the minimum wages, you have to divide it by 30. That is what they are saying, madam. So 19,000 is the monthly wages, madam.
Yes.
Now, lordship will kindly turn to page 165.
Yes.
This is part of the wage cut of the NNF Railway. Lordship is lordship will kindly see column 1, unskilled worker, wage rate per day 651.
Yes.
And then lordship comes to column Roman 12.
Yes.
The contractor's liability is 19,426. So when the daily salary is 651, the monthly wages is 19,426. And when it is 655, it is more by 4 rupees. It is less by 200 rupees. Man, how is that possible?
No, I didn't get it. I didn't get it.
Man, when we come to page 157,
157, yes.
the daily wage is 655.
Yes.
Yes, my lord. And the monthly liability,
Yes.
I have shown the calculation is 19,199.
By multiplying by 26.
26.
Ah.
Now, same railways, when the wage is 651.
651.
And the first column, man.
Yes.
The monthly wage comes to 19,426. It is, the wages is less by 4 rupees, but the monthly emolument is more by 200.
The minimum, my lord, to selling limit, my lord.
No, man.
Your selling 15,000, my lord.
Huh?
Minimum selling limit is to
Let me submit, man.
15,000, my lord.
He'll get his done.
12% multiply by
He'll get his done.
15,000 divided by 30, my lord. But 60 will come, then 60 into 30, my lord, 1,800.
Ah, we'll take it up later. Mind is not functioning. Blood.
Say, we meet a party because whether our calculation is wrong or
Ah.
right, they are the right person, they can see.
In a safety concern, if two views are possible, my lord, views of the authority should be accepted, my lord.
That is a different thing, my lord. One interpreting the terms of the contract, my lord. Here it's a statutory provision, my lord. They cannot take a stand contrary to the
No, my
statute,
lord.
man.
In own record, my lord, I will
and-
show, my lord, is it
he had-
800 for the whole month, my lord.
Huh?
This is a contribution, my lord. Contribution for not for 26 days, it is for whole month, my lord.
And
The
it is-
X says, man, for the whole month, my lord.
My lord, it is
Not
not,
for 26 days.
it is not the
The
decision of the respondent number 4, my lord.
prescribed, my lord,
It is the
for
decision of the
26 days.
railways, my lord. The railway has to defend.
I am
not the
a-
private
I am a
respondent.
holder, my lord. I have to defend my client.
Anyway, my lord, lordship will take it up for admission, my lord. This is listed in the orders column.
Huh?
This is listed in the orders column.
No.
So let it come up in the admission column. If your lordship is not taking up today.
Already by this-
I don't know because I've got one item at 2. After that, we are free, no? Oh, what's some more matter? 2 more matter. Oh,
Those are hearing it.
hearing matter. Okay, this is slightly, yeah.
He pays for time, my lord.
I'm not praying for time. I'm not praying for time.
Okay, right. counsel for the parties submit that pleadings are complete and the matter can be disposed of accordingly. List this matter in the admission column. After
After 13 months, 13 of May.
Let it be on 15th of May, Malord,
already were fixed.
because they are already running the contract, Malord. It is to my prejudice.
It is subject to outcome.
It is subject to the outcome. What will happen? Nothing will happen. Can it be in the next week, Malord?
No, no, no.
8th of May.
We have fixed lot of matters.
This tarikh.
Well,
Yes, my lord, I have obtained instruction. He has not submitted this. He has not deposited 15%. But my lord, if I may submit, my lord, in terms of the NIT, it is said that if you have submitted, give details. If you have not submitted, then nothing to be mentioned. So it is
honest
not
money.
honest money.
Let us see what the NIT says.
My
Is it requirement? Is it a essential condition?
I'll take your lordship to the vernacular one, page 20. Page 20 and my lord, page 21.
Ah.
প্রথম বছরের নির্ধারিত ন্যূনতম বজারের 15% হিসাবে কল ডিপোজিট মর্মে যদি জমা দিছে, if you have deposited, then তার নাম্বার, তারিখ আর ব্যাংকর নাম, then details of the bank draft and other details. So if you have deposited, so that is.
So it's not a requirement.
Clause 7. In the translated copy, kindly 7
Ah.
on the page.
Yeah,
19.
yeah.
The tenderer should
Enclose the following
The
document.
translation may be wrong, therefore I read the vernacular.
No, but that is what you have submitted. Now.
My lord, I have,
That is our document.
Yeah.
but therefore I have read out the.
But where does it say earnest money?
That is in no, my lord. Proof regarding 15% deposit of first year reserve price. As you have got it, right, along with the date and bank form, bank name.
If deposited, যদি জমা দিছে। যদি
Even, my lord,
যদি জমা দিয়া
suppose the condition is there to deposit earnest money. You know, can have a look at the global paragraph 7. Without earnest money, this single judge of Calcutta High Court directed to deposit earnest money after closing. The paragraph 7 clear elaborate this. Paragraph 7, my lord, global. And you got paragraph 7. It amounts to creating a new tender. Therefore, what I submit, my lord,
Yeah, it should be with the following document. This one.
My lord, if I may also refer to one judgment, my lord, in this regard, regarding earnest money only, it is 2013 4 GLP 566. There, my lord, this issue was taken up. And in fact, my lord, the single judge had allowed the petition against which appeal was made. Appeal, the finding was not interfered with. I'm just reading out paragraph 11 of the single judge's judgment quoted therein. It is no doubt true that the authority stipulates any condition in the NIT, those are required to be fulfilled and cannot deviate from such condition unless, of course, those are essential conditions of eligibility and not merely ancillary subsidiary with the main object and to be achieved by such condition. In case any condition stipulated in the NIT is merely ancillary or subsidiary with the main object to be achieved by such condition, it is open to the authority to deviate from, not to insist upon the strict compliance of the condition in appropriate cases. Now, in this case in hand discussion, there is no stipulation in the detailed terms and condition of NIT of the NIT supplied to the petitioner as well as to the respondent, but the other bidders that the earnest money has to be deposited only in the form of.
Out here, there is no condition stipulated, but out here it is stipulated.
Here, the case was that there was no condition stipulated how the money is to be deposited, although.
But out here it is
Minor, but
stipulated,
minor.
madam.
That's true. And then, my lord, it is said that.
And now you see those judgments now, AFCON's judgment is there.
That,
Now there and.
that of course I'm not
they-
insisting.
Even Milord,
I'm not insisting.
that still ancillary.
No, that is what she's reading basically.
Yeah,
That
so-
judgment is based
so
on
it is-
Podarski,
that
probably,
Podarski-
ancillary and essential.
There are
Milord,
lots of, I have come-
Central fulfill.
You see, the question of deviation can be allowed for ancillary. For ancillary conditions, deviations can be allowed. For essential conditions, it has to be given to everybody.
Yes.
So that is not the issue here. That is not the
Milord,
issue
In
taken up by you.
fact, Milord, Central Coalfield judgment, Justice
General
Mokul
Court
delivered,
is-
wherein the Pudar Steel was discarded. Because Pudar Steel never discussed earlier Ramanna Dayaram said the three judgment. If you deviated, then prospective buyer, bidders, the opportunity of eligible would have been participated because of the deviation. That was laid down by three judgment of Ramanna Dayaram. And that was not considered in Pudar Steel, and therefore Pudar Steel was not relied in Central Coalfield case. And
Anyway, now that is not the issue. Here, the tender conditions as translated by the petitioner says should contain the following document.
My lord, may kindly consider the vernacular one.
No,
This
I
is
am
by
going to,
the-
I am going to consider your translation. You cannot say that, please, this is my pleading, please don't consider my pleading.
No, my lord. It is a translation, but the lordship.
Okay, we will ask is the submission of earnest money an essential condition or is it ancillary?
It is essential condition.
That's enough. Afghan steel is there. Okay, right. Heard Ms. P. Chakrabarti, Learned Counsel for the petition. Also heard Ms. R. Chitri, appearing on behalf of respondent number 1, 2, and 5. Acha, 1 and 5, huh? What about 3? Who is appearing for 3? And 2 for fishery? Mr. M. Chettiar for 2, 3, and 4. Alright, then how come 6? Acha, 5 is?
I will register.
Who is for 5? Acha, 1 and 5, no? Mr. S. Kataki for point number 6. The petitioner is agreed with the settlement of the Kukur Mara Group Fishery and the Kolgasia Group Fishery Revenue Circle with the respondent number 6. In terms of the settlement order dated 8/1/2025, on the ground that the respondent number 6 was a defaulter in respect of the Akara AKARA bill, which had been settled with the respondent number 6 via settlement order dated 25/7/2023. Next paragraph. The petitioner's case is that it submitted its bid in response to NIT dated 1/10/2024 for settlement of the Kukur Mara Group Fishery under the Kolgasia Group Fishery Revenue Circle, along with the respondent number 6. The petitioner was the second highest bidder, while the respondent number 6 was the highest bidder. The authorities thereafter settle the Kokurmara Group fishery with the petitioner by settlement order dated 8/1/2025. However, due to an interim order passed by this court on 17/2/2025, the possession of the Kukurmara Group fishery has not been handed over to the petitioner. Point number 6. Next paragraph. The petitioner's counsel submits that the petitioner is a defaulter and as such could not have been settled with the Kukurmara Group fishery. In this respect, the petitioner's counsel has relied upon the letter dated, where is that? The letter dated 21/8/2024 issued by the Additional District Commissioner bracket fishery dated 21/8/24, wherein it has been stated that the petitioner has paid rupees 45,000 to the government as revenue with effect from 2021-2022 till 2024-25 financial year in connection with Ganak Para Akara Bill in Barpeta district, Chenga Revenue Circle, under Tarabari PS, and an amount of rupees 20,55,000 is due to be paid by him to the government. Next paragraph. No, continue. The counsel for the petitioner thus submits that the settlement order dated 8/1/2025 should be set aside, and the petitioner should be settled with the fishery. Next. Mr. S. M. Chetia, the learned counsel for the respondents number 2, 3, and 4, submits that the petitioner did not submit his earnest money, correct, along with his tender pursuant to the NIT 1/10/2024, and as such, the petitioner's tender has been rejected. Then what about that defaulter business? He also submits that in terms of paragraph 6 of the affidavit filed by the respondent number 2. Respondent number 3. Respondent number 3. The number 58 Akara Bill fishery in Barpeta district has been settled with Batgaon Naya Para Shri Ganga Machya GB AG at the rate of rupees 3 lakhs per annum for a period of 7 years to be counted from the date of handing over the possession of the fishery. So you are a member of the society or the society?
Not a self-help group.
Self-help group. The petitioner, no, that is point number 6, who is a member of the self-help group, correct?
Yes.
Of the said self-help group, has deposited security deposit of rupees 45,000 and has got the possession of the said fishery on 15/7/2024, and accordingly he has time to pay the remaining amount of rupees 20,55,000 till 15/6/2031. As such, the society cannot be considered to be a defaulter. Also, the society has paid rupees 2,59,000 out of 21 lakhs till date and has no pending dues. Full stop. Next. That's all. I don't need to. Next para. I have heard the learned counsels for the party. The question whether the respondent number 6 has got pending dues in respect of the number 58 Akara Beer Fishery in Barpeta district has been categorically denied by the respondent number 3 in para 6F of the affidavit in a position filed by the respondent number 3, which is as follows. Take it para. Next para. In view of the question of fact being answered by the state respondents to the effect that the petition is not a defaulter, this court does not find any grounds to allow the writ petition. The writ petition is accordingly dismissed. And right, in view of the dismissal of the writ petition, the I is accordingly disposed of. Interim orders passed earlier stands vacated. What is that? No, sir, this is what we got. No, not that.
I'm newly engaged, Lordship.
Huh?
I'm newly engaged, Lordship.
Newly engaged.
Today I filed a follow command. Some accommodation.
2017 matter, Mr. Counsel. There is a stay order here. Is there a stay order?
No.
What is this for? What is this?
For return of SD money, Lordship, security division, security.
Is it return of SD money?
The contractor did not continue the contract work on the ground of his ill health. That is the thing.
But then you see, the question of you being ill had been communicated by you only after
Yes,
after the termination of the contract.
yes. Lordship.
Not prior to
I have
that.
seen-
Then
I have seen.
Hmm?
Yes, Lordship, I have seen.
then what remains? That is the sole question. Nothing to be decided.
Yes, sir.
You were given a contract work. You have said that since you are ill, it should be given to someone else and you cannot continue with the contract work. But that reasoning has been given by you only after the contract was terminated, not prior to it. Then what remains? Is there any arbitration clause?
No,
No. Where is your agreement with the authorities?
agreement is not an.
Then how do you know there is no arbitration clause?
That is the thing, sometimes.
Why?
Otherwise, Lordship, I have no case. I have, so far I have gone through it, your Lordship, because I have communicated after the termination. So
Correct.
far I have seen you.
So what is wrong?
This much, your Lordship,
Huh?
1 day or 2 days. Your Lordship, I will-
What is your name?
R.A. Choudhury.
Mr.
R.A. Choudhury.
R.A. Chowdhury.
When
Have you filed a wakalat?
Yes, sir.
When?
Today, Lord.
Okay. Submit that. He will be appearing for the petitioner and in this regard, he has submitted a wakalat nama today. He accordingly prays for adjournment for a few days. To enable him to prepare for the case. Next paragraph. The matter pertains to the termination of the contract awarded to the petitioner and the forfeiture of the security deposit and performance security due to the petitioner not completing the contract work. It is the case of the petitioner that due to his ill health, the petitioner could not complete the contract work and he had requested the authorities to appoint somebody else to complete the contract. That's your case. On the other hand, it is the case of the state respondents that despite being given numerous chances to the petitioner to complete his contract work, the petitioner could not complete his contract. And the same led to termination of the contract work as well as forfeiture of the performance security and retention money, correct?
Yes.
The further stand of the state respondents is that the petitioner informed, the petitioner's contract work was terminated on 23/9/2016. While the contractor, while the petitioner had informed the respondents that he was ill and could not complete the contract work only on 3/10/2016. Now, that is after the termination of his contract work by the respondent. List the matter on when.
Any day.
Huh? Next Tuesday? You said any day you're not ready for.
Yeah.
Huh? You give a date, you give a date.
Tuesday.
Alright, use the matter on 6. There's hardly any matter here. I don't know, what do you want?
Only thing, is there any arbitration clause in the agreement or?
Just see that.
I have no case.
Correct. You just see, I think there has to be an arbitration
Yes.
clause. There will be. There will be an arbitration clause, then you can apply for that.
Because the moment he received notice, he given a representative.
Who is for the other side? Huh?
PWD.
Who is the Mr. Gogoi? So just see that. If there is an arbitration clause, then he can go for arbitration. Otherwise, he's got no case.
Yes.
So you be ready by Tuesday. If no thing, I'm disposing it off. There's nothing here.
Obliged.
Case, there's some development, my lord,
Yeah.
that taken place. Here the petitioner, the PF organization has imposed some penal damages against the respondent number 2, which is the Ascot Bank. And against that, he went an appeal, appellate court has passed an order, against that we have come. In the meantime, my lord, what happened, if lordship kindly peruse this, the bank has been liquidated, my lord, and the liquidator is appointed. Therefore, I must treat the liquidator also.
The respondent number 2 has been
Liquidated.
Liquidated.
The registration is cancelled and liquidator is appointed. One Mr. Mohan Peron has been appointed, the joint registrar has been appointed liquidator. I will treat him as a.
okay, right. Mr. P.K. Roy, Learned Senior Counsel, assisted by Ms. A. Chakrabarti, for the petitioner submits that the respondent number 2 bank, ASCARD, bracket, has been liquidated and Shri Mohan Peron, MOHON, TERON, Joint Registrar of Cooperative Societies, head office, has been appointed as the liquidator of the respondent number 2 bank. Mr. P.K. Roy submits that he would like to implead the liquidator and accordingly prays for time. Leaves the matter after 2 weeks.